Judge Bellis.
Here.
Judge Cobb.
Here.
Judge Farley.
Here.
Judge Hernandez. Judge
Here.
Judge Hernandez is here. Judge Wynn O'Dowd.
Here.
Judge Prats.
Here.
Judge Trulia.
He is here.
All right, full house. Welcome, everybody, and I appreciate everybody's patience as we try to navigate this agenda remotely. The first item on our agenda is the approval of the minutes from the September 14th, 2020 meeting of the Rules Committee. Just so we're clear who's making motions, if you're going to make a motion, please state your name and what the motion is. So is there a motion to approve the minutes from the September 14th meeting?
Motion to approve, Judge Bellis.
Moved by Judge Bellis. Is there a second?
Second, Avery Whetstone.
Thank you. Is there any discussion or changes to the minutes as drafted and distributed? If not, all in favor say aye.
Aye. Aye.
Aye.
Opposed, say no. All right, that passes unanimously. And for the next two items, I'm going to, just so we're clear, I'm going to first ask Attorney Del Campo to try to bring all of the members of the committee back up to speed. And then if you've had any discussions with anybody independently about who would like to frame the discussion for purposes of today's meeting and addressing the committee, that would be very helpful.
That'd be fine, Your Honor. Yes.
Before we start, could everybody please make sure that you have your microphones muted unless you are speaking to the members of the committee? It will help tremendously with this many participants. Go ahead, Joe.
So this proposal originally came in from Judge Adelman. He was proposed by Judge Adelman in September 11th, 2018. Had to do with this hybrid appearance pretty much across the board because he had suggested amending section 3-8 of the practice book, which is a general provision of the practice book. It went through many different referrals, and it did get some support, although ultimately it was decided that it would not be a good idea in civil. So ultimately on this list of items, we're pretty much starting at level I, letter I, which is the redraft of the proposal, which is it's a redrafted iteration of this, which focuses on family matters. Judge Alvis is here to discuss it, I think, a little bit. It basically focuses on family-only matters, and it does incorporate a provision from section 4-2, which has to do with when attorneys are in the proceedings, have filed appearances, they need to sign the document. So that's pretty much where we're at now. That is letter I. It's the redraft. 25-6A has to do only with family matters. And I don't know if Judge Alvis wants to expound upon that.
So first, Joe, thank you very much, Joe. That's exactly what I was hoping you were able to do, because there are a lot of sub-items in this item. So I just want to make sure everybody is looking at what was sent to us in sub-I, which was a email from, something from Joe, and it includes a new draft of the section 25-6A in red line strikeout language. Judge Alvis, I see, is joining us as well, and this has gone through a lot of work, a lot of revisions, and a lot of hard efforts by both judges and others within the judicial branch. And I want to thank Judge Alvis, Judge Heller, and all the others who participated. I'll turn it over now to Judge Alvis.
Thank you, Justice McDonald. And I will note, I did speak with Judge Heller the other day. She had a busy docket today and not able to join us, but I told her that I would relay to the committee that she and I had spoken. And the basic position I think we have is that we only thought this would be appropriate if anywhere in family. And one of the concerns we had all along and I think some of the civil judges shared it, is that by trying to regulate cases where self-represented parties filed motions without their attorneys joining, we might be implicitly recognizing that that's an okay thing to do, which wasn't our goal. But we tried to draft it in such a way, and the changes over time, I think, improved it to try to limit its focus. Judge Heller did make me aware of some other proposals that were made regarding section 4.4-2 concerning what happens when an attorney doesn't sign, or what the requirements are. And she and I talked about those proposals, and as I understand them, they would say that if a self-represented attorney party wished to file a motion, the attorney of record would also have to sign the motion, at least to verify that the rules had been followed, that notice had been given appropriately to the other party, and in one version of the proposal, that the motion was not based on a frivolous grounds. And those proposals, I think both Judge Heller and I thought made sense and were maybe another way of coming at the issue. And under the proposal, that rule would say that a motion not meeting those requirements would be deemed rejected, or could be deemed rejected. And my only concern about that aspect of it was that I don't know that clerks can be expected to pick up on and reject these items as they come in, which can't really be done effectively in e-filed cases anyway. But that if at any point before the matter was heard, if the other party or a judge on his or her own motion saw that that rule had not been followed, that it could be raised. So I'd be happy to try to address any questions. It is a thorny issue because we're trying to square the rule that requires the attorney to sign with the reality that in family cases, we have many matters where an attorney still has an appearance on file and a party has filed a self-represented appearance as well. And especially in post-judgment matters, those attorney appearances can linger in the file for a long time after that attorney has really finished doing the work that he or she was hired to do.
So I just want to be clear that that last part that you were talking about with deeming it rejected is not included in this newly drafted language, right?
My understanding is that there was an alternative proposal about the signature on pleadings, and I apologize, I'm not sure I have in front of me exactly what the committee members do.
Oh, I'm sorry. Good point. Joe, what? Is that 4-2?
I think you're correct, Your Honor, that proposal, that part about deeming it to get rid of the document that the self-represented party filed, that is not in this proposal. I think that the CBA litigation section did suggest that that would be a good idea, but it's not in here. I think that, let me just see. This one says that the unless and until a motion filed by a duly represented, dual representation without party, let's see.
I think the substantive language is in subsection B. Judge Bellis, were you raising your hand to address this item?
Only because I think I had originally suggested it, and we had circulated that to the different groups, and the CBA was on board with it. But then I think what happened is when it sort of deviated off to family only, it sort of got lost there somewhere.
Okay, so we're not dealing with that language in this proposal, and this is specific just to the family situation. And Joe, I just want to be clear, since Judge Alvis doesn't have what we're talking about that you circulated to us, Is this the language, the substitute language that was the culmination of the efforts by Judge Albus, Judge Heller, and others for family matters?
Yes, it was. All we did was we just redid the language a little bit because it had some confusing language in it, and we sent it back. Yes, this is the Judge Albus, Judge Heller language that we just made it look a little bit more in line with the practice book terminology.
Right. Okay. Are there any other questions from members of the committee? And I can't see everybody, so I do see Judge Bellis. She'll go first, and then any other members can just pipe up.
So I think my original concern was consistency, because the same litigants bounce back and forth from family court to civil court. They get sued for the collection from their divorce attorney, or they're suing the divorce attorney for legal malpractice. So I have a big issue with just having this separate set of rules in family and not in civil. I think it's too confusing, and there's no good reason for it. I did want to just ask Judge Albus, what happens sometimes in civil when we have this situation where, and it does happen with some good frequency, where you have a self-represented party also represented by an attorney, and the self-represented party wants to file pleadings and the attorney either is not on board or doesn't know about them. Sometimes the self-represented party will just file a new in lieu of appearance to remove the attorney from the case without a motion to withdraw appearance. I don't really know if that's proper or not. I know it's done all the time. I never make an issue of it, but I'm just wondering, because I understand what your issues are, and you see it a lot, but does that, when you have that situation and you have a motion that's not in accordance with 4.2, does that ever happen where to get the matter adjudicated, they just file an appearance and remove the attorney? So that would sort of solve the problem in a way.
It does happen, I think, more frequently in post-judgment matters where the party had a self-rep appearance and the attorney did for quite a while, and maybe one post-judgment motion was filed that the attorney helped with, and then a couple of years later, the self-represented party, not even thinking that that attorney is still in the case, files their own motion. And when that happens and it comes up for a hearing, I do feel comfortable suggesting that the self-rep file a new appearance in lieu of the attorney, because the attorney isn't really involved. But when it's an ongoing matter that's not gone to judgment yet, and one pendente lite motion may come up that maybe the attorney didn't feel comfortable with, we try, and a concern we had in our working group was not to create a rule that forced people to get rid of their attorneys in order to pursue a motion, even if it wasn't well-founded. So we didn't want to create an environment where fewer people were represented. So if the attorney was truly out of the case, then that's fine. But we didn't want to make situations where a self-rep had to, in order to pursue one motion, go it alone on everything, and now we've lost the benefit of having an attorney represent the client in that matter.
So if I could just ask a follow-up question, Justice McDonald. So, because I might have confused myself here. So is the thought process that it's sort of up to the judge in a way when you have the situation of the pleading that's not in compliance with the practice book, and is the thought process that actually it could go forward at some point, either that day or another day, without the attorney ever signing it?
We wanted to leave it in the judge's discretion to be able to do that.
And what would that, because I'm just trying to understand what the difference, why not, I guess why in a way? Because doesn't that sort of lead to, problems? If it's something that changes the way the case is directed, or if there's a difference of it, I could just see two people calling the shots and having it sort of chaotic.
It can be.
Yeah.
Unfortunately, I don't know what we can do to eliminate chaos completely from these cases. The concern we had was that the judge had no clear direction on what the options were, and might be open to being questioned as to the choice they made and letting the matter proceed or not. We really don't want to force judges to tell litigants, you can go ahead with this motion, but you have to get rid of your attorney to do it.
Right. And what about, was there a discussion in your working group about rejecting the pleading and then let it be refiled with the attorney's signature, so now you know the attorney knows, and letting the self-represented party pursue it and argue it, and not have the attorney involved? You know what I mean? So then we're all assured that the attorney knows what's going on, the other side. Because I'm also wondering, if I were on the other side and I saw one of these motions not signed in accordance with the practice book, I would be making a big stink about it. So like,
and sometimes people raise it and then we address it. Other times they don't. I don't know that we talked about the middle ground that was suggested, that the attorney of record could sign off and say they know about it, but I'm letting my client handle that by himself or herself. We wanted the judge to be able to decide either the attorney is adopting this and representing the client, or if not, the client is on their own.
Okay, thank you.
Judge Albus, I had a question. The language that we have in subsection B says, among other things, that the court in its discretion can order that the proceedings on the motion be stayed until an attorney of record adopts said motion, as if it were signed by that attorney. Is that a sua sponte effort, or would an opposing party be permitted to file a motion asking the court to determine whether the attorney representing that party subscribes to the motion? Is it just self-initiated, or could an opposing party initiate it?
I think it could be either. I don't think we intended that it require the other side to raise it.
Well, okay. I mean, I think we should probably have some clarification for that, to say that the court may, on its own motion or motion of a party, order that proceedings on the motion be stayed until an attorney of record adopts it. Would you have any objection to that?
I wouldn't, no.
Okay. Before we move any further, do any other members of the committee have any questions for Judge Albus on this subject?
At this point, I would note that Judge Edelman does have his hand up. I don't know if that's for this particular point.
Thank you. I can't see all of that, so thank you very much, Shana. Judge Edelman, would you like to address the committee?
Yes, thank you. It wasn't the desire of the suggestion of the committee that the attorney had to necessarily handle the motion. You know, part of the impetus for this was to help to protect the attorney on the other side, so that he or she would know who they could talk to. So I think the intention was that the attorney of record would sign off saying, yeah, this has been done properly, but my pro se client is handling it, and you can negotiate with him. It wasn't an effort to force the client to pay the attorney to prosecute the motion.
Thank you. Other comments or questions? Is that Judge Farley?
Yeah. I just have a question. I wasn't sure why anybody wanted to encourage hybrid appearances. I understand the point that has been made here that, you know, in part it's an effort to hang on to attorneys in cases. But I'm wondering whether, rather than approaching it by just generally opening the door to hybrid appearances in family court, whether you could flip that around where if a represented party wanted to pursue something as a self-represented party, they could simply ask permission to do that. And so that would avoid creating hybrid appearances in any number of situations that don't necessarily meet the rationale for allowing hybrid appearances.
Judge Albus, would you, Judge Bellis?
So that was a great point, and someone last year made that same point. It surely wasn't me, because I didn't even realize it, but there's a practice book section 3.8a. Whenever an attorney files an appearance for a party, or the party files an appearance for himself or herself, and there is already an appearance of an attorney or party on file for that party, the attorney or party filing a new appearance shall state thereon whether such appearance is in place of or in addition to the appearance or appearances already on file. I think it was Judge Alexander, but I can't remember exactly who it was. So we all last year sort of read that practice book section to allow for the hybrid appearances. So we sort of put that issue to bed back, whether we're right or not, I don't know, but that was sort of the consensus last year when the issue was raised.
Well, so I thought that, I know the rule is not exactly a model of clarity, but there is some case law on hybrid appearances that really puts a thumb heavily on the scale against allowing them, except under exceptional circumstances, which is left to the discretion of a judge. And, if that were clear, then it would open the door to approaching it this way, and you'd have a much narrower, scope of cases where you might have hybrid representation going on, and it would give the court a lot more control over when and how that's allowed.
Judge Albus, did you want to respond to any of that?
Well, I think, as Judge Bellis points out, the rule implicitly allows a self-represented litigant to file an appearance in addition to that of the attorney. And while we're not trying to encourage that, we wanted some clarity for judges who are faced with the situation where a motion is filed by a self-represented litigant who does also have an attorney of record. Because there is some case law, but it's not really clear. And we thought clarity in some form was needed. And we tried to strike a balance between encouraging more self-reps to do this without their attorney and giving the judge some options on how to deal with it, either staying the proceeding or letting the litigant proceed at his or her own responsibility. But we just thought some clarity would help.
And I see Judge Adelman has his hand up. Judge Adelman.
Thank you. The what prompted me to make this suggestion for a rule change in the first place was a very fine decision by Judge Tobin that came out in June of 2018. U.S. Bank N.A. Versus Marco Divisio. It was a foreclosure action, but he talks at length about the history of the hybrid representation and comes to the conclusion, citing some other cases, that there is no right to hybrid, but it's not prohibited. In the court, allowing a self-represented party and an attorney, the idea was to make sure that the two of them, the attorney and the client, were speaking with one voice. And I know in family, this is a significant problem where pro se parties will file motions, the attorney doesn't know anything about it. The attorney on the side has no idea who to call. So I think we need some kind of rule. I understand the reluctance to give an
I'm
impetus.
sorry, Judge Edelman, are you talking about on the civil side too?
Well, you know, the civil judges tell me it's not that big an issue, but I would think it would apply to civil cases as well.
My
The case
recollection.
that Judge Tobin wrote on was a foreclosure case.
So my recollection, and Judge Bellis can correct me if I'm wrong, I thought Judge Abrams told us that he was not convinced at the moment that it was necessary on the civil side, and that it's almost as if it was suggesting, I don't want to put words in his mouth, that it should proceed on the family side. Let's see how it works on that before we address it on the civil side. Judge Bellis, does that comport with your understanding?
100%.
Oh, okay. All right. This has been a long time coming, but I think what I'd like to do, and hopefully this is the last time, is to table this. I did make a suggestion that there should be an amendment anyway. I think everybody should have that language in front of them. And this will be last call for input on this subject. If you have any further questions or concerns with the draft, please get in touch with Judge Alvis and Attorney Del Campo at the same time. I want Joe to quarterback this for the committee so that we don't have a lot of paper flying around, and he and his team need to have a clear understanding of what's going on the subject. We will reconcile this once and for all, and if all goes well, and I certainly hope it will, we will be able to have a vote on this at our next meeting. Does that sound okay with everybody? Okay.
Justice McDonald, can you have Joe send a copy of it to Judge Alvis so he could circulate it among the family judges?
Absolutely.
Thank you.
All right.
Just
Joe?
Just one other comment on that. If this is now written just for family under 25, chapter 25, I'm just wondering now if it's not going to go to civil, perhaps you want to amend 3-8 to at least give some notice that this exists. So it would say something like in 3-8A, except as otherwise provided in these rules, or except as otherwise provided in 25-6A. I mean, you're going to want to reference, I think, for the practitioners, the idea that there's another rule out there in family that governs this process, perhaps, just to think about.
That makes sense. So, Joe, when you get us a new version of this, have that
Okay.
Have that incorporated as well.
Okay.
Okay. We'll table that for 1 more month. Next item is the proposal from Natasha Pierre, the state victim advocate, to amend several rules and sections related to crime victims' rights. We tabled this last month, I believe, so that Judge Gold, I think, and Judge Alexander were working on a potential alternative to not necessitate a rules change. Is that correct, Joe?
Yes, sir. It is. It is perfectly correct. We also were to look into the ITD possibilities of a notification, the notification capabilities, which Shauna did look into quite a bit. And it appears that none of the judicial branch systems at this point have notification capability. It was not built into those for this process. And I think Judge Gold and perhaps Judge Alexander did speak of an alternative device, which would be forms created by judicial to go out, which would obviate the need for these rules changes.
And I believe I saw Judge Gold is in the meeting. Judge Gold, can you?
Yes, thank you, Justice McDonald. I am in the meeting, and thank you for recognizing me. May I speak with regard to this proposal?
Yes, please.
Thank you. I did, after taking over from Judge Alexander 8 weeks ago, learn of the need to review certain proposed rules. I was provided with a rule involving changing sort of the discovery rules and another rule that pertained to hospital arraignments. I understand that those were not put on today's docket, but will appear next month. I was not made aware of this particular Office of Victim Advocate proposal would appear today. I did speak to Judge Alexander about it, but I was led to believe, and apparently erroneously, that this proposal to create some forms in lieu of the wholesale rule changes that Ms. Pierre was proposing was going to be satisfactory and would, I guess, eliminate the need for the Rules Committee to consider her full proposal. I may be wrong in that respect, and if I am, I would certainly request the opportunity to review Ms. Pierre's proposal further and report back at the November meeting, which I am told I'll be doing regarding the discovery and hospital arraignment proposals.
Okay, so first of all, welcome to the warm water. So I think what I would ask, unless there's alternative suggestions from members of the committee, I'd ask that Judge Gold get together with the Office of the Chief Public Defender, the Office of, I see Deputy Chief State's Attorney Lawler is on here, and Natasha, Pierre is also on here. Maybe you could either talk individually with those stakeholders or have a Teams meeting to kind of flesh this out in advance of next month.
I'd be happy to do that, and I'll attempt to find a convenient time, particularly for Ms. Pierre, to understand whether my what I've heard is right or wrong, and be ready to respond in November.
And I'm sorry you are getting dragged into this. This has been something that's been going on for some time, and they will need some time to, all of them will need some time to really bring you up to speed with what the challenges are and what the proposal was aimed at achieving. And then we can talk next month about whether there are alternatives short of any rules change that would be more efficient or effective in achieving the goals that Ms. Pierre identified.
I'm happy to do that. May I only ask maybe Ms. O'Donnell if I can have access when I attempt to click on these materials that appeared on the agenda, so that I could review the comments of the Chief State's Attorney's Office and the Office of the Chief Public Defender. I get some sort of screen that says I need to tell you why I need the materials. So if there's some access code, if I could be provided.
We will get that, either hard copies or give you access to it.
I appreciate that. Thank you, Justice McDonald.
Okay. Before I close out that item, we did have other invited guests. Understanding that this is not going to be taken up today, did Ms. Pierre or Attorney Lawler want to address us on that subject at all? Yes, Attorney Pierre.
Yes, I would just love to see what is being developed. Judge Alexander and I did talk, or were going to talk briefly, but then COVID hit, and this kind of went to the back of the aisle for our agency right now, because frankly, during COVID, we've gotten the best notice and best involvement we could ever have. But I would like to really have a discussion with Mr. Gold and see those materials to see if it's getting to what I was trying to get to.
Yeah, just so you know, Judge Gold, if it wasn't clear, he succeeded Judge Alexander as the chief.
Oh, okay.
Criminal. So he's in charge of the bailiwick at this point. Attorney Lawler has his hand up.
Okay, so I.
Yes, Your Honor, thank you. We'd be happy to provide any input necessary in order to bring Judge Gold up to speed on our end of this issue and provide any help that you'd like. So just let me know and we'll have somebody involved in it.
Okay, and Joe Del Campo, maybe you and Shayna can facilitate all of this to make sure that they are all connected at some time with enough advance notice so that we can have a more meaningful discussion about it at our next meeting. Okay, anything else from members of the committee on that item? Okay, moving on then, the next item is the proposal from Judge Noble to amend section 10-60 concerning amending pleadings. This is the first time that this item is on our agenda. Joe?
Yes, I'm sorry. Yes, first time on the agenda. Typically, you would like to refer it different places. I suspect to the CAJs and the CBA at least.
Yes, I'm frankly, I looked at it. It's the whole section is a little odd, I thought. I don't know why. I just looked at it quickly, but are not subsections 1 and 3 essentially duplicative of each other? I shouldn't say duplicative, but if the, what I didn't understand from Judge Noble's email is that this is he's suggesting that the requirements of subsection 3 be imported into subsection 1, but it seems premature because subsection 1 is an order of the judge to file an amendment. Am I reading that? Judge Bellis, yes. Get me out of my morass.
I think that that's just a distinction between when you file the motion to amend and get the order versus the request to amend, where sometimes there's no objection and then it's just deemed automatic. But actually what I wanted to point out was, I'm not sure, Joe, that we need to notify all the CAJs because this is just for civil. Okay. So I was thinking probably, don't you just want to notify Judge Abrams since it's only for civil matters? Whatever.
Yes, you're correct. That would be best. Judge Abrams.
Judge McDonald.
Yes.
A couple of things. Judges sometimes, I think, under 1044 may issue an order that a substitute pleading be filed. So the 1, 2, 3 in section 1060 covers all the bases. But I wanted to recommend that in addition to Judge Noble's suggestion on amendments, and in particular, that the redlined new document be filed in 1 and 3 of section 10-60, I wanted to recommend that it also be required when a plaintiff files a complaint as of right, which I have had issues with recently, and they just file that within the 30 days of filing the complaint. But sometimes issues are raised as to motions to dismiss, and plaintiffs try to cure it, and then they file a pleading as of right, but you can't tell what was changed. So I was going to recommend that we think about making the same change as to 1044 and as to 1059, 1059 amendments as of right, and 1044 substitute pleadings ordered by the court.
I'm having flashbacks of having side-by-side documents that I had to go through as an attorney, Judge Bellis.
I agree with Judge Cobb, and quite frankly, even if it's by written consent, because we spend an inordinate amount of time having the side-by-side documents and figuring out exactly what changes were made. It's so much easier when it's redlined. And maybe if it's a small case, it's not a big deal, but when you're talking about more complicated cases, so I don't really see any, I think he had a great idea, and I agree with Judge Cobb. I think we should just, expand it across the board, yeah.
I also agree. Are there any other comments from members of the committee? So, Joe, what I would ask you to do is to take Judge Noble's suggested changes and, I'm sorry, Judge Cobb, was it 10 dash, what section was it?
1044 and 1059.
Okay. Yes, have those.
And forward that to Judge Abrams for his comments.
Okay.
Okay?
Yes, sir.
Anything else on that item, folks? Okay.
Maybe just one more thing, Justice McDonald, and that is that it may be that we need either like we put this in a separate section, the redlining, and then refer to the statutes instead of putting it in all the statutes. Do you know what I'm saying? We should think about structurally how it goes in the rules.
Well, okay, we can think about that later. Let's just start the ball rolling with getting it to Judge Abrams so we don't lose any more time. You're suggesting a new standalone section. It concerns me a little bit because people tend to just look at the section of the practice book that they're focused on, and they might not be thinking about another cross section unless it's cross-referenced.
Okay, well yeah, so one or the other, either include it or cross-reference it. But right now, the way it's written, it's connected to subsection 3 of 1060 paren A. Right. So we would need then to, if we want it to be specific, we would need to add it to 1 and 2, which makes no sense.
So yeah, so there's probably other precedents in the practice book for keeping that uniform, and I'll leave that to our legal staff to make sure that we are consistent with our past practice so that there's uniformity.
Sounds great.
Okay.
And at this point, Justice McDonald, Judge Truglia has had his hand up.
Oh, I'm sorry, Judge Truglia.
No problem. Justice McDonald, we have amended pleadings in family 2 from time to time. So perhaps we could refer to Judge Albus as well.
That makes sense. And if you or one of the other family judges have the practice book sections, I'm sure Attorney Del Campo can find them too, but it might be quicker if you just shoot him the relevant sections.
25-8.
There you go. Okay. Anything further from members of the committee on that item? Okay, very good. Next is the proposal from Attorney Petra Zelly to revise section 2-8 to replace outdated language regarding persons with disabilities. I thought we already did this. Is this another one, Joe?
Hi, Justice McDonald.
Yes.
Yes, I
Yes.
was joking, Joe, about this because I don't want you to think all I do is sit around and proofread the practice book, but sometimes these mistakes pop up when you're doing a totally unrelated project. So I was helping with updating the index to the practice book, believe it or not. And when we were looking up the removal of the phrase physical or mental disabilities, it became apparent that it was corrected only in section 2-9, but that language should have been removed this year in 2-8. So now we're going to propose that the language in 2-8.3 conforms to the changes that the committee already approved for 2-9.
Okay. Is there any discussion from members of the committee? Seems pretty technical. Joe, you were talking and are muted. Did you have anything you wanted to say?
Yes.
You're muted now.
1 second. Takes a second. Sorry, it takes a second to go on and off. Lori did review this. As she said, we do have some discretion with the reporter of judicial decisions when we're reviewing these things to make technical changes. I just felt that this was a little beyond that, but if you think it's a technical change, to add a whole sentence to this rule, then we can do it that way. But I just thought there was a little that you should see it.
No, I appreciate your sensitivity to that. So let's just do that as a motion. Is there a motion to approve that change?
So moved, Judge Bellis.
Moved by Judge Bellis. Is there a second?
I'll second it, Judge Farley.
Seconded by Judge Farley. Any discussion? All in favor, say aye.
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 Opposed, say no. That passes unanimously. The last item on our agenda is a report to the Rules Committee pursuant to Section 1-9C. This was a outgrowth of our actions at the beginning of the pandemic, and we included a new rule that said that the chief administrative judge of any division in consultation with presiding judges and with the approval of the chief court administrator could make certain changes to the practice book, but had to report them to us. And Joe has an update for us on that.
Yes, this was part and parcel of the emergency changes, as Justice McDonald indicated. Along with that, though, the judicial branch did, through the governor's office, was able to secure what is known as Executive Order 7G, which suspended all the different statutory provisions that had to do with practice and procedure. And that's how we dealt with proceedings during the height of the pandemic. So a lot of different statutory provisions concerning time limitations and requirements were suspended. We also had to, as Justice McDonald said, suspend certain of the practice book provisions that dealt with different timeframes, and two of them, 3-2 and 17-30, dealt with defaults. There were several statutory provisions that dealt with defaults, and the suspension of those was lifted recently when judicial wanted to go back in and do some of these defaults, but we had to use 1-9C in order to basically suspend the suspension of the rules. There was no other mechanism to do that. So this allows the judicial branch to go back in and move on all of the different defaults in all of the different areas. And it's now consistent with the executive order, which has been lifted.
And really my recollection of that is that unless we take negative action, those changes remain in place. So they would be unsuspended and they could keep moving forward with the defaults. We actually don't have to do anything now that it's been reported to us.
Correct.
If we agree with it. Okay. Is there any disagreement with the action taken? Seeing none, we will take no action on that item. If you all followed along with that. Okay, I don't have anything else on the agenda. Joe, is there anything else that we need to be attending to?
No, sir.
All right. Did anybody have anything they wanted to say before we adjourn? If not, I'll accept a motion to adjourn.
So moved, Judge Cobb.
Been moved by Judge Cobb, seconded by Judge Hernandez. All in favor, say aye.
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 Opposed, say no. Thank you very much, everybody. We stand adjourned.
Thank you.
Thank you.